Hi, I'm Victoria Merritt, a lawyer with Ascent Employment Law. Today, I want to provide a brief summary on severance, as it's one of the topics we advise on most often. As I explained in my video on just cause dismissals, the legal default is that a terminated employee is entitled to either notice of their dismissal or pay in lieu of notice, which is often called severance. Only in rare circumstances can an employee be dismissed without notice or payment in lieu of notice. But how much notice is required? The answer to that question depends on three things. First, each province in Canada has what's known as minimum employment standards legislation. In BC, that's called the Employment Standards Act. The Act sets out the absolute minimum amount of notice that an employer has to provide if dismissing an employee without cause. Unless you're one of the few employees excluded from the Act, your employer has to pay you this minimum amount. They can't negotiate that amount with you, and they can't make you sign anything in exchange for that payment. The second thing that needs to be considered in a severance assessment is your employment agreement. If you have a written employment agreement that clearly states you're only entitled to the minimum that's payable under the legislation, then that will limit your entitlement to just that. However, it's always a good idea to get legal advice on whether that contractual restriction would actually be enforced by a court, because there's a lot of specific rules relating to how those termination provisions must be drafted. The third consideration for severance pay is what's known as common law notice. This is essentially the amount of notice that a judge would decide to give you, and it's based on four factors: your age, your length of employment with your employer, your role, and the availability of a comparable position, taking into account your skills, training, education, and experience. While common law notice is almost always significantly more than the employment standards minimums, it also brings with it what's known as a duty to mitigate. That means that you as a dismissed employee have an obligation to seek out comparable employment. If you don't make efforts to find new work, or if you find new work during the notice period, then the money the employer owes you can be reduced accordingly. The lion's share of our practice deals with the issue of severance and entitlements on dismissal. If you're an employee who's been dismissed, or an employer who's looking to dismiss an employee and have questions about calculating severance, we can help.